Admissions and dear colleagues, I, Preeti Sharma, on behalf of the entire DOR 2025 committee, welcome you to today's deliberation on the anatomy of an enforceable award, mapping responsibilities of courts, institutions, and arbitrators. Swadharme nidhanam shreya, paradharmo bhayavaha. This shlok from Bhagavad Gita reminds us that true order and justice arise when every participant fulfills their rightful responsibility without evasion or excess. Courts ensure the sanctity of enforcement within the framework of law. Institutions provide the procedural backbone that instills confidence and efficiency. Arbitrators entrusted with quasi-judicial authority shoulder the ethical and intellectual responsibility of delivering justice. Like the limbs of a single body, each of these actors functions distinctly, yet harmoniously, to give something called life to an enforceable award, so that enforcement is not an accident of the procedure, but the natural outcome of a delicate architecture and well-orchestrated responsibility. A failure in one sphere reverberates across the entire process, undermining both legitimacy and trust in arbitration itself. With this thought, let us begin our journey into the anatomy of enforceability, guided by our distinguished speakers. Ladies and gentlemen, we have on the panel today Ms. Xian Bao, one of the most highly ranked who's who legal global elite leaders, often described as a force of nature when it comes to working as an arbitrator. Ms. Xian is a chartered arbitrator and CEDR accredited mediator with over 20 years of experience working in London, New York, Hong Kong, and Singapore. Ms. Xian currently serves as a co-chair of the IBA's International Arbitration Committee and is the past vice president of the ICC Court of Arbitration. It is my privilege to introduce Mr. Viren Mascarenhas, founding partner of Mascarenhas Law PLLC, New York. With over 2 decades of experience, Mr. Mascarenhas is a distinguished international arbitration practitioner, having acted as counsel in high-stakes disputes across industries ranging from energy and mining to life sciences and luxury goods. In addition to practice, Mr. Mascarenhas is a lecturer in law at Columbia Law School, a fellow of the Chartered Institute of Arbitrators, and has been consistently recognized for his international arbitration work. We are elated to have on board Mr. Tejas Chauhan, Director, South Asia, Arbitration and ADR ICC. As the Regional Director at the Secretariat of the ICC International Court of Arbitration, Singapore, Mr. Tejas is responsible for structuring and implementing IC's strategies, overseeing operations and promotion of ICC dispute resolution services in over 20 countries. Prior to joining ICC in Singapore, Mr. Tejas also worked with ICC in India and with the forensic and dispute advisory services at a Big Four audit firm. He is also an avid promoter of opportunities for young practitioners and leads ICC's Young Arbitration and ADR Forum for South Asia. Next, we have on the panel Ms. Shaneen Parekh, the partner and head international arbitration at Cyril Amarchand Mangaldas. Ms. Parekh is dual qualified as a solicitor in India and also in England and Wales. She is an advocate on record, Supreme Court, and a registered foreign lawyer of the Singapore International Commercial Court. She is the vice chair to the ICC Commission on Arbitration and ADR for a 3-year term till June 2027 and serves on the Council of the Mumbai Center for International Arbitration and an ambassador of Asia Pacific Arbitration Group of the International Bar Association. The present session is chaired by none other than Honorable Mr. Justice Hrishikesh Roy, former Judge, Supreme Court of India. As all of us know, Justice Roy went on to serve as the 35th Chief Justice of the High Court of Kerala in 2018, before being elevated to the Supreme Court of India as a judge on 23rd September 2019. Throughout his career, Justice Roy spearheaded several pioneering initiatives, including the Reach Out and Respond program for marginalized communities. His efforts in producing impactful films such as Shako on mediation and Apne Ajnabi on racial prejudice stands as a testament to his innovative approach in spreading legal awareness. Ladies and gentlemen, with such illustrious record of recognition across multiple platforms, it is an honor to welcome all the speakers on board, and I request Honorable Justice Roy to take the discussion forward. Ladies and gentlemen, please, a hand of applause.
हो गया टेस्ट कर लेना I suppose people are trooping in still, and we don't see the full house as yet. But since sessions are timed, we'll just start the process. Now, the four panelists here have been introduced very adequately by the person who is taking on the show. And so I just want to recognize the presence of Justice Karia and all the eminent members of the arbitration fraternity and my co-panelists. Arbitration, as you would appreciate, is not merely about rendering awards in disputes behind closed doors. It must achieve its fruition. And unless people are able to enjoy the fruits of the award, then the entire process is actually a stillborn process. Now, keeping this in mind, this particular session pertaining to the anatomy of an enforceable award, mapping responsibilities of courts, one party, institution, another party, and arbitrators, will try to take this discussion forward. Now, any award, unless it passes masters and succeeds in the test of enforcement, that award has no meaning or value to any of the stakeholders or the participants in the dispute. An award which cannot be enforced, I think, is meaningless in the hands of the award holder. And I learned of the difficulties and the frustration of an award holder from a foreign jurisdiction trying to enforce the award in Indian jurisdiction. In one of the judgments that I dealt with, one of the cases that I dealt with as a judge of the Supreme Court last year. This was the case of Avital, and lo and behold, the time when I held the case papers in my hand, I understood that this was the third occasion the award debtor had come to the Supreme Court, the highest court of the country, third occasion, third challenge to the enforcement of the award. So that immediately made me realize how frustrating it is for somebody who is victorious in the process of arbitration and is still not able to enjoy the fruits of that victory. So in that judgment which I wrote, I had to say again, and we had to reiterate yet again, that mere allegation of bias or procedural dissatisfaction do not constitute sufficient grounds to refuse enforcement, unless such bias strikes at the very heart of justice. If an award has to suffer multiple court intervention, the arbitration will simply mirror the litigation battle, slow, costly, and court-dependent, and the very purpose of arbitration will be defeated. That brings me to the foundational question. What would be an award which will be enforceable by a court of law? Obviously, it will be an award which will contain the reasons, which will take note of the submission of the rival parties. It will obviously have to be signed by all the arbitrators. It must satisfy the procedural formalities. And to speak on the responsibilities of the different players in the process of arbitration, we have a very eminent panel who are very carefully chosen by the organizers of this DAW initiative to give their input in the process of arbitration so that we have enforceable awards in our hands. Now, as we know that enforceability is the ultimate goal of all the stakeholders, and in order to give an example of how an award may have to require the institutional intervention at the appropriate time, I may just like to tell a story of the Lord Krishna. Those of India are familiar with Lord Krishna, and I'm going to tell the story of by comparing an award with Amrit, which was churned from the ocean of milk in the battle between the Devas and the Asuras. Lord Krishna is there. So I would like a few volunteers, if I may have. Can I have a few volunteers on stage? I'll need 4 to be precise. Please come here on the front of the audience, and we'll do a short story. Okay, right. Now, I have the 4 volunteers, and just don't block. You can come in front of my chair. Then you'll not be blocking anyone else, right? Okay. But at some point of time, you'll have to block, right? Okay. Now, I have Mishika Bajpai, right? Now, Mishika Bajpai will play the role of Mohini. Her role is very important. Then, Ananya Sikri, you have the role of Krishna. Now, Krishna here is the institution. Then we have Arjit Sanyal. How come you have been picked as the Asura? Okay. And then we have Pranav Ahuja. You are playing the Deva, right? You are representing the Deva group. Now, this is the battle between the Asuras and the Devas. The Devas are losing their strength, and Lord Krishna advises the Asura that if you can get hold of the Amrit from the ocean's depth, you will regain your strength and you will become immortal. Now, this particular secret is also known to the Asuras. And the Devas, with their diminishing strength, are not able to, on their own, churn out the Amrita from the Samudra bottom, right? So Krishna suggests to the Devas and the Asuras will step one step forward, to the Devas and Asuras, that why don't you combine together get hold of the Amrit, and thereafter you can share the Amrit and become immortal. So the Asuras are also getting interested, and they said, all right, we'll help. And Devas naturally are interested because they are already losing their strength. So now the battle goes to, let us say, to the Supreme Court, and Supreme Court says that this battle should not be dealt with by the court, but through a process of arbitration. And arbitration by who? Under the auspices of DIAC, right? So it's a DIAC arbitration. DIAC, I can for short say Krishna. So we have Krishna here. So she is the Krishna, the DIAC here in this battle, arbitration battle, and we have Mohini there. She will have a very important role. Now we are having this battle of the the Devas and the Asuras, but in this process of churning out the Amrit from the ocean, they are together in one mission, right? And you are trying to get the Amrit, churning. And let me just get hold of the Amrit, and Amrit is brought out from the ocean's depths, right? And at this moment, Amrit is here, then Asura, please come here. He's got hold of the Amrit in his hand, and Asura is about to consume the Amrit. Now, mind you, if the Asuras consume the Amrit, don't, and not yet. This has to be actually told by Krishna. Krishna, you should say that not yet. Please line up, form a line so that all of you can share the Amrit equally. You tell that to the Asuras. I have the lapel mic, you can speak here. Yeah.
Asuras, not yet. Please form a line and then you may consume the Amrit.
Right. So just keep it down, keep the Amrit down. And now I am having the Asuras distracted by Mohini. Now Mohini is a very pretty lady, right? She emerges out of the Krishna's, the Mohini emerges, and she is trying to distract. You please come here. Devas, you come here. Now she is trying to distract the Asura from the Amrit side. You have to walk with your heels clicking, right? And you have to entice him away. You have to follow Mohini. Now, while the Asura is getting distracted, Deva, please have a gulp of the Amrit. Okay. So Deva is having the gulp of the Amrit, put it down. Now, Krishna, who is the Divine Lord, is playing the role of the institution, the DIAC here. Please come. Now you don't have to stay away. You can have a swig of Amrit also. So what I'm trying to say is that in a process of arbitration, there would be situations where the arbitration process by the award debtor can be challenged, some procedural irregularity, some defects in the drafting of the arbitration clause, or whatever those may be. And the institutional perspective can then be brought into the draft award, and those can be corrected so that it is the actual award holder who enjoys the Amrit or the award in the process of churning. So that's why this small thing, I hope you will remember the story of the individual role of Krishna, the DIAC, Asuras, Mr. Sanyal, then Ms. Sikri, you are the Krishna, right? No, you are the Krishna, right? And Pranav Ahuja, the Devta. And how did you like Mohini? Did you hear the hills and the temptation in her steps? Right. So now we'll take on the next process. Thank you, all the volunteers. Thank you very much. Thank you very much. Okay, after this small interlude, which might have woken you all up, in this important DAW event, we have Ms. Qian Bao. And those of you who may not know, she is now turned exclusively into being an arbitrator. And I was a little intimidated after learning during the morning coffee that she's a regular marathon runner. A round of applause for the marathoner, the marathon girl, Ms. Chianbao. So the other profile you will know very well. And then we have Viren Mascarenhas. He's a fellow of the CIARB, and he frequently sits as the arbitrator. And in the ICDR, AAA, and the CPR panels, he also teaches in the Columbia Law School. Very impressive, very impressive. And I met a couple of his students who had occasion to attend to his lectures. And the students are so smart, so I knew that the teacher being present has added a lot to this panel discussion. Then we have Ms. Shanin Parikh with her wonderful experience in the field of arbitration as a partner in CAM. I'm sure she will be bringing in her own practical experience to this discussion. And at the appropriate time, we'll ask her the right questions so that she's able to enlighten us. And the final panelist, he looks very innocuous and innocent. But being a representative and the regional director of the Secretariat of ICC International Court of Arbitration in Singapore, he brings very valuable institutional experience to this discussion, and his input on various aspects or steps of arbitration, including the preparation of the award and pronouncement of award, will have a very interesting takeaway for all the people who are present here. Now, very often we notice that sometimes the arbitration process or the award is resisted, enforcement is resisted on the ground of some defective drafting of the arbitration clause. Now, on that, if we can have the input of both Viren and Ms. Bao on, please tell us, both of you, one by one, maybe Viren first. Please tell us how careless drafting of the arbitration clause can cause problems at the enforcement stage. Also provide your input on how enforceability of a final award is impacted through orders passed on interlocutory application granting interim relief. Would you kindly also shed light on the procedural missed steps at the interlocutory stage which might have a bearing during the enforcement process? Viren first.
Sure. Thank you very much, Justice Roy. And I don't know whether to be offended or relieved that you didn't ask us to be the volunteers in what we just saw. I think relieved. I'm also a little bit scared of what you might ask us to do in this panel session with that precedent. It's an honor to be here, so thank you. All right, so I've now started my own disputes boutique firm, but before, when I was a partner at various US law firms, the way that the arbitration clauses get drafted is usually by the transactional lawyers, right? And we made a joke during the pre-call planning session, and I'll attribute it to Shanin, who said, maybe we need to rewrite the title of this. You know, it's responsibilities of courts, institutions, and arbitrators, and parties. And perhaps we could also add parties counsel, and actually further parties transactional counsel, right? Because that clause that's drafted in your contract is really one of the biggest steps towards achieving enforcement ultimately if you go to arbitration. It also tends to be the clause that transactional lawyers don't focus on that much. In the momentum of let's close this deal, right, we don't think about the bad things that might happen if we end up fighting over the promised transaction. And so it's not uncommon to get a call closer to signing where someone says, could you just quickly look at this clause? And the strong undercurrent to that statement is, and can you just leave it alone, really? We're doing this as a pro forma check with you, but we don't want the input. Now, one interesting thing, when you look at the IBA guidelines on drafting arbitration clauses, they actually warn you to not get too detailed in your arbitration clauses. and with good reason. You don't actually know what position your party is going to be in oftentimes when you're drafting these agreements. Will you be the plaintiff or claimant? Will you be the defendant or respondent? Will it be a big break the company dispute coming out of this agreement? Or will it be a relatively small portion of performance under the agreement that can be dealt with quickly? So, there's a tension here, right, between wanting to be prescriptive from the outset versus drafting a succinct clause that allows flexibility both for the parties and the arbitrator, the tribunal, as you go through the arbitration. And that tension is when you have to apply judgment, what matters and what does not matter. Now, there was a lot of things that were asked in that first question. I don't want to, incur the wrath of my fellow panelists by taking a stab at all of it. So I'll start with a couple of things that I think about that you should avoid or you should be cognizant of when you're drafting that arbitration clause, and invite my panelists as well, under the direction of Justice Roy, to add in. The first thing is, institutional versus ad hoc. I'm going to be very short on this point because I know everyone says in India there's a strong preference for ad hoc arbitration. Historically, there's changing momentum with very respected institutions that have been on the scene for a while now, and that virtues of administered arbitration by an institution versus ad hoc have been discussed. But it is a threshold question. And here's then the other part. If you're choosing an institution, get the name of the institution right. It is very often the case, and actually don't blame the parties here. Maybe I'd even blame the ICC. Is it the ICC or the ICC Court of Arbitration? The ICC Court of Arbitration, rules of arbitration. It is a mixture of words, right? You see center, you see court, you see arbitration, you see international, you see administered, you see non-administered. So it's not surprising that there can be confusion as to what you're choosing. But this is where choosing carefully matters, the institution and getting it right. That sounds simple, but it's very important. And the other comment that I'll say on a fundamental element of a clause is the place of arbitration. I understand now with the proposed amendments, there's efforts to clarify things like, here, place, seat, venue, which often gets tied up in litigation to figure out what's meant. Place and seat in the international arena tend to be used interchangeably. But I would tell the parties, don't give up on your choice of seat. Really try to wrestle that one out with the counterparty. If you don't end up, it's going to be with a seat, it's okay. Usually you'll be able to figure it out with the tribunal in place, assuming you can get a tribunal in place, which may be hard if you don't have a seat specified. But that seat really matters. It matters both to get things up and running. It matters because those courts are going to have supervisory jurisdiction over the arbitration. And it also really matters because when we get to the end of it, if we're dealing with a New York Convention award, you're going to be dealing with those courts for the set-aside process. Both substantively, what are the grounds of set-aside, and then what is the reputation of that judicial system when it comes to dealing with those awards. So seat matters. And my final third thing, and then I'm going to hand it over, is time limits. There is a real focus right now, including in the proposed amendments, for efficiency, to get things done in a specified period of time. I'm a big proponent of time limits. However, constraining the process in your arbitration clause without carve-outs is difficult. And this is because sometimes it may be that your dispute is relatively small and can be expedited or fast-tracked. But it may be that it comes down to a critical issue in the performance of the agreement. Termination for cause, for example, application then of liquidated damages or penalty provision, depending on how it's interpreted, sort of something that will bring the relationship between the parties to a halt. You may need more time there. And so my only comment on time limits is, if you're going to use them, be careful with being realistic, but also give an opt-out. Let the institution or the tribunal have discretion for cause to be able to extend. So those are my tips on getting that clause off in the right direction.
Chian, would you like to take it forward?
Certainly. Thank you very much for the kind introduction. I didn't appreciate that my running hobbies would feature in this morning's session, but there you go, and thank you for the acknowledgement. Viren raises, I love the way in which he sets out the practical tips, and I'd like to follow on with some of the ideas that I think I've seen as an arbitrator and working backwards as to what I wish had been agreed upon in the arbitration clause. I will say at the outset, I don't have much to add, because I hope that actually arbitration clauses are meant to be clean, simple, and as close to the institutional model clause that you choose as possible. But looking backwards as to what issues have arisen once the dispute arises that I wish were agreed upon prior to in the arbitration clause, I would raise 3 particular points. One, know that the arbitration clause, if it includes institutional rules, know what those rules say because you are incorporating it by reference. And so to the extent that you have included the number of arbitrators, for example, but then you find yourself in an expedited arbitration, know that there is a contradicting term in the arbitration rules themselves. And so you have to be mindful of those types of contradictions because not all enforcing courts deal with them the same. A second point that I would raise is the law governing the arbitration clause. And the reason why I mention that is because oftentimes we see that, in fact, that decision has not been expressly agreed upon, and again, enforcing courts don't treat the issue consistently. And so when I was at the Hong Kong International Arbitration Center as Secretary General, one of the things we did in revising the model clause was include an optional clause as to the stipulating what the law governing the arbitration agreement might be. And that removes any doubt as to what the parties have agreed upon. And typically, of course, you know it will be either the seat or the governing law. And certain jurisdictions like the UK have expressly stipulated that now in their legislation, in their Arbitration Act. But not all jurisdictions are created the same. And so it's important for the parties to at least put their mind to that particular issue. And the last point that I would raise is in relation to the potential that the arbitration clause is not between 2 parties, is part of a suite of contracts, is part of a bigger project, and many institutional rules, but not all institutional rules, now have provisions dealing with those scenarios. And so if you, as a transactional lawyer, want to become more creative, or the transactional lawyer and the disputes lawyer want to anticipate issues, be careful as to what you include in your contract, because you might have a 1-page consolidation provision, but in fact the institutional rules that you have incorporated by reference also includes a consolidation provision. So these are the types of issues that you want to be mindful of when you are in fact dealing with your arbitration clause.
Thank you, Xian and Viren, for bringing the perspective from your experience, long experience in the field of arbitration. Now, can I bring in Shaneen? You have worked with several international contracts, particularly involving Indian clients. Now, can you make your suggestions for drafting appropriate arbitration clauses, which would not only smoothen the arbitration process, but would also ensure effective enforcement of awards? Shaneen? Yeah.
Thank you to the organizers and ICC. I have some here, sorry, for inviting me. Thank you also, Justice Roy, for giving me a tee-up to this comment in terms of Amrit, which is obviously the fruits of an enforceable arbitral award. I agree with everything that Xian and Viren have said. I think if you're looking, when is the best time to start thinking about what will go into an enforceable arbitral award? It is the time of drafting the arbitration clause. And depending on the kind of transaction that you have, if it's purely domestic, is it international, where you may need a neutral arbitrator or seat, all of these factors weigh into what you will put into the clause, including where you will enforce it. So very quickly, and some of this may overlap with what they've said, but I think we can just go step by step. The first thing, of course, is that because arbitration is an alternative to court litigation, it's a voluntary process. So there must be clear intention to arbitrate. Parties must be ad idem, of the same mind. Indian courts and also several sophisticated jurisdictions have ruled time and over again words like may refer the matter to arbitration is not sufficient to show that there is a clear intention to arbitrate. So while drafting, please be very clear upon every word that you include. The second thing is the scope of the arbitration agreement and the scope of the dispute of the arbitrator's jurisdiction and the disputes that will be referred to arbitration. Generally, unless there is very clear need, a widely worded arbitration clause is best. Why? Because if there is a dispute or a part of a dispute that does not fall within the scope of the clause, you will not be able to arbitrate that. The arbitrators will not have jurisdiction, and you may have multiple proceedings, if not an invalidation of the arbitration clause itself. The third thing, of course, which is very important and I think is actually the most hotly negotiated part of the clause in any cross-border contract, is where is your seat of arbitration. Now, Viren referred to the word place, which is what is used in our Act. Section 20 uses the word place 3 times. Twice it refers to seat, once it refers to venue. I generally prefer using the word seat so that you avoid any potential argument on that at all. Why is the seat important? Because it is the courts of the seat that will govern the arbitration process. So if you're 2 Indian parties, you may be absolutely fine going before Indian courts. But if there are 2 parties of different nationalities, generally they want a seat that is neutral so that they're not subject to the jurisdiction of the other party's national courts. What I really wanted to actually talk about was also the law of the arbitration agreement. And I think Chian mentioned that in the UK, post their recent amendments in Jan, the default rule is that the law of the arbitration agreement will follow the law of the seat. What is the law of the arbitration agreement and why does it really matter? It is the law of the arbitration agreement that determines one aspect which is quite critical, and that is whether the dispute itself is arbitrable. And I'd say the importance of specifying the law of the arbitration agreement came very recently to the fore in a case between Anupam Mittal and Westbridge. And what happened was that we effectively have conflicting rulings from the Singapore courts and the Indian courts, by virtue of which I think everyone now recognizes, and I don't know if ICC has it in their rules, but the SIAC rules now expressly include a line for law of the arbitration agreement. And in Anupam Mittal, what had happened was this was a dispute in relation to a shareholders agreement. Anupam Mittal, Indian national, Westbridge was a fund investing in the company. The SHA was governed by Indian law. The seat of the arbitration was Singapore. The clause talked of referring disputes to arbitration before ICC, and notably, the clause also referred to disputes concerning the management of the company. I say that because that relates back to scope, and that also relates to why the Singapore court ruled as it did. Now, what happened is, and many of you will have seen this as a tactic that you may have employed or that has been employed against you. Anupam Mittal filed proceedings in the NCLT for oppression and mismanagement against Westbridge. Now, as we all know, oppression, mismanagement is not arbitrable in India. It goes to the statutorily set up NCLT. However, O&M cases are arbitrable in Singapore, and Singapore was the seat. So when Mittal filed the O&M proceedings in the NCLT, Westbridge went to the Singapore High Court and said, I have an arbitration clause, please grant me an injunction, anti-suit injunction restraining Mittal from proceeding in the Indian NCLT. And there the Singapore High Court, and this was upheld by the Court of Appeal, ruled taking into account the arbitration clause, which referred to disputes relating to management of the company, ruled that the arbitration clause therefore had to be governed by Singapore law, and because under Singapore law, O&M disputes are arbitrable, it could be arbitrated there, and it granted the anti-suit injunction. Mittal went to the Bombay High Court to ask for an anti-enforcement against the Singapore anti-suit and argued that O&M disputes are not arbitrable in India, and if you allow this arbitration to proceed, there will be an award that is not enforceable. And the Bombay High Court accepted that argument, effectively saying that there's no point really in this arbitration going ahead because it will have to be enforced in India, and therefore it granted the injunction sought. Now the matter is pending in the NCLT, the arbitrations are stayed. It may be that the NCLT may find that actually this is really a cooked up defense and it's a contractual matter which can be referred to arbitration. But this, we're talking about something which was September 2023 and nothing has proceeded. So you've got that many years to go before an enforceable award. And all of this could have been avoided if the parties had negotiated very clearly what the law of the arbitration agreement is. And if this arbitration were to proceed, assuming that you chose Singapore law as the law of the arbitration agreement, what would happen to your award? Well, it may not be enforceable in India, but it certainly may be enforceable if the award debtor has assets anywhere else in a New York Convention country. Sorry, so I went on a bit.
No. Thank you, Shaneen, for bringing in a comprehensive perspective on enforceability and the difficulties that which might relate to careless drafting of the arbitration clause. Now, let me bring in the institutional perspective here. Now, Tejas, with his huge experience at the ICC, can you highlight the difficulties faced during institutional proceedings attributable to a poorly drafted arbitration clause?
Sure, sir. Good morning, everyone. So when we saw the skit, which was on the arbitration, and Davis was mentioned, the only Davis I could think of was Antrix versus Davis, which of course had its own enforcement issues. I will address the point, which is Viren's point on choosing the institution. If you're choosing the institution and if you're choosing the ICC, it is the International Chamber of Commerce. It is not the International Cricket Council, the ICC. So if you do choose ICC, it is just the ICC. Do not choose any other institutional rules. Now, of course, the ICC and the institution comes in very later if you don't follow what my friends Chian, Viren, and Shaneen mentioned. At the ICC, the regular issues that we encounter are, of course, the issues pertaining to whether the parties wanted ICC arbitration, because there could be a mention of another set of rules, or there could be a mention of court itself. Second is that the parties may perhaps attribute the characteristics of an arbitrator in the clause itself. So when they were drafting the clause, they might want a particular arbitrator, and they might define the characteristics of that particular arbitrator. So again, do not be very creative with your clauses. Do not impose timelines in the arbitration clause itself. So many a times you also encounter clauses which say that the arbitrator shall be appointed within 15 days, and the arbitration award shall be rendered within 30 days. Now this is again imposing on the institution to act against its rules, because the ICC has rules which prescribe for certain time limits. And of course, the ICC is also empowered to raise those time limits, but again, some of these common issues without taking a lot of time.
Thank you, Tejas. We'll move on to another aspect of the arbitration process. Now, in certain arbitration process, when a tribunal deals with a foreign law, often adequate briefing of the tribunal members is either lacking or it is less than what it ought to be. Otherwise, the tribunal itself might assume similarity with the law at the seat of the arbitration, and this would lead to various difficulties. Now, Ms. Chian, can you please offer advice to the tribunal to navigate this foreign law vacuum in the process of arbitration, especially when challenges founded on wrong application of law by the tribunal is mounted at the stage of enforcement?
Thank you very much for that question. Let's take this in the logical next phase based on where we are with the arbitration clause and what's been discussed, and now looking at the fact that the parties have chosen a law that may not be the law that the tribunal collectively are, the arbitrators as a tribunal are qualified in, and how that might play out. Now, obviously, parties have the opportunity to choose their own arbitrators, and this is part of the beauty of international arbitration. However, what ends up happening sometimes, especially when we're not dealing with, I suppose, the traditional seats and the traditional governing laws, is that we may have a question as to whether the arbitrator knows the law. And whether the arbitrator knows the law, the question is, the short answer is, of course they do. This is the short answer. This is the assumption that arbitrators know the law. However, it requires also the parties to engage with that governing law that has been chosen. So in the instance of Indian law, if it's chosen as a governing law and none of the arbitrators are qualified or experienced in international law, how is this disconnect dealt with by the parties? Now, much ink has been spilled on the way in which parties should be approaching this disconnect. However, practically and from a procedural perspective, it's useful for the arbitrator to know that this vacuum may exist, and also recognize that not all parties understand how international arbitration is dealt with on the international stage. So oftentimes you will see a repeat player and a first-time player in international arbitration, and you have this scenario where you may have one side with significant experience in how to deal with that foreign law, so to speak, and the other side that may not have as much experience, but may perhaps have great experience in that local law or that foreign law. And so the way in which the tribunal must be sensitized to that is through process, and the fact that, and in short, it is the fact that you have no surprise in the process, and ensure that parties have a fair opportunity to be heard and have their questions answered, or the tribunal's questions answered during the course of the proceedings. And so after all, the tribunal has to satisfy themselves that they are rendering an enforceable award, and in doing so, they have to satisfy themselves that they have addressed the specific nuances and the issues associated with that foreign law.
Thank you, Ms. Chair, for domesticating the foreign law syndrome for the benefit of those who are present in this hall. And if I may now go over to Shanin, we have certain occasions when a party is not represented during the arbitration process, or is poorly represented, or it's a party themselves, not a trained lawyer who is appearing. Now, if an award is then rendered, let's say an ex parte award, or an award which is then put to challenge on the ground of procedural fairness, what would be your advice in a situation like this for the arbitration tribunal?
So, it's very clear that a self-represented or what they call a pro se party or litigant, or where one is not represented at all, there is clear inequality of firearms. For the self-represented party, perhaps he's using a catapult as against an Uzi. For the non-represented party, that is usually, I think, a conscious call. So you look at it from, there are ways of looking at it from a counsel's perspective as also from an arbitrator's perspective. From a counsel's perspective, I have had self-represented parties appear against me. There, I think, okay, so let me step back to what you would do. Before that, what could happen? It's obviously a potential due process violation, this kind of inequality. Our Act currently provides equal treatment for parties, and it talks of each party being given a full opportunity of presenting its case. If a party is not given a full opportunity of presenting its case, that can be a natural justice violation, rendering the award unenforceable. unenforceable or challenged in the seat and actually set aside. So what do you do in those kind of situations to make sure you do have an enforceable award? So when it is a self-represented party, as counsel, I try to be gentle and accommodate an arbitrator who I know will need to perhaps explain procedural issues to that party. Now, I actually sat as an arbitrator recently in which a party was self-represented and was relying almost exclusively on AI for all their submissions. Now, what an arbitrator should do, and most arbitrators do, I've seen this both internationally and domestically, is to explain the process to the self-represented party so that there is nothing that's missed out, so that they are able to take decisions on their own, seek legal advice if they want, and they should, of course, but they know what is happening. So to give you an example, where I was sitting as arbitrator, the party, the respondent, filed a memo which he referred to as his witness statement. Now, ignoring form over substance, substance over form, it was just that. It was like a note. It was not a witness statement. Now, that party had the burden of proof on certain issues, and without a witness statement would not have discharged his evidentiary burden. I spent quite some amount of time explaining the consequences of not filing a witness statement and not putting a witness open to cross-examination by the other side. The respondent asked me to guide them and said, we will file if you ask us to file, which of course I could not, because then that disadvantage that the respondent has becomes a disadvantage to the claimant. So it's a very fine line between ensuring that each party knows exactly what it is up against, how the process works, but a balance before tilting that what is now known as due process paranoia to advantage the self-represented party. In terms of a not represented party, I think that is quite clear both internationally and including our Indian courts. In Centro Trade, I remember, as long as that party has received adequate notice, but has chosen, it's a conscious decision that they do not want to represent themselves in the arbitration, that is fine. As long as notice has been issued, and I would suggest repeatedly and in writing, there is no natural justice violation. That said, that does not mean that the award can be what we refer to as a default judgment, but must nevertheless be a reasoned award on the merits of the case so that the claimant still has the burden to lead evidence to prove his case, which must be considered by the tribunal, and only then the award issued, which would then become enforceable.
Yeah, Viren, you want to add something?
Yes, please. Just to give a practical example of that, I recently sat as an arbitrator in a case where there was a claimant represented by counsel, and there were four respondents. 3 of those respondents were pro se, unrepresented, and the 4th was a no-show. So what we had to consciously make sure to do was the email address of the 4th respondent, the no-show, also mysteriously stopped working. So we started getting bounce backs, right, when we were sending out notices of procedural hearings and things like that. And so the precaution that had to be taken, I was the sole arbitrator, was sitting in New York, communicating with everyone, including the undeliverable email address, by email, but then taking a hard copy and couriering it to the address of the contract, listed for the party in Singapore. And then getting that notice of delivery. That happened a couple of times. Then after some time, the guy wisened up and stopped accepting my couriers. So I kept the records of the attempts to deliver and unsuccessfully, and included all of that information in the ultimate award. All of the attempts, the emails, the couriers that were received, then stopped being received, and details of the tracking to satisfy any subsequent annulment challenge that may be made to show notice of constitution of the tribunal, initiation of the arbitration, constitution of the tribunal, and the opportunity to participate in all steps to the end was done. It's time-consuming, expensive, and annoying sometimes.
No,
but
actually, it's lovely that you sort of thought it fit to bring this to the notice of this house, because you have really sort of taken pains to, root out the difficulties which might lead to a successful challenge to the award, final award. Thank you, Viren, for your input. Now,
Justice, may I
yeah,
just-
please,
Sorry,
Sharmila.
I omitted to make one comment. I referred to our act talking about full opportunity to be heard, right, to present their case. Because this is, in a sense, being abused by self-represented and most often by non-represented parties, one of the proposed amendments to the Act is to change the word full opportunity to fair and reasonable opportunity. And I think that is eminently
That's significant.
sensible.
That's significant, right? Tejas, if I can now turn to you. Now, institutions like ICC and other institutions occasionally step in, but I would like to know from your practical experience, does the ICC intervene suo motu in the arbitration process? And if so, under what possible circumstances they do so?
Right, sir. So it happens under, of course, there are decisions that the ICC takes, which are administrative decisions that the ICC takes on its own accord. For example, fixing of the fees of the arbitrators, deciding on the number of arbitrators, appointing these arbitrators when the agreement does not provide for, deciding on the place of arbitration. The ICC may also step in, for example, when the clause provides for expedited procedures, which is fast-track arbitration, but the complexities of the case require that this is perhaps something which could not be fast-tracked. Now, these are perhaps administrative decisions. The ICC on its own will also step in to perhaps make appointments of arbitrators where the clause might say that one party will appoint all the arbitrators. The ICC might step in to replace an arbitrator. Now, again, the rules provide for this, but this is something which is used in rare circumstances, exceptional circumstances, with the idea of promoting and safeguarding the interest of arbitration. So we've had cases where the ICC had stepped in to replace an arbitrator who did not have hearing dates available at the request of the parties. We've stepped in a particular case where the ICC replaced an arbitrator because the arbitrator cancelled or did not show up in the last two hearings without any intimation. So again, all of this to protect and safeguard the process. The ICC on its own will also reduce the fees of the arbitrators if the arbitrators are delayed and the delay is unjustified. The ICC will do it not just for the arbitrators, but the ICC court will also reduce the fees of ICC's own administrative expense when the ICC is delayed in decisions which it has to take within the rules.
Okay. Thank you, Tejas. Actually, these are important aspects that is brought in. And particularly, sometimes the ICC having to step in to deduct the fee and also reduce the fee of the institution itself. And there is a proposal, perhaps the co-panelists may or may not know, for bringing about an amendment to the Schedule 4, the fee structure under the Indian Arbitration Act. Now, yesterday I sneakily said that only recently I have started to work as an arbitrator. So would there be a retrospective amendment of this Schedule 4 fee structure so that we are not bound out by the fee that is imposed? But now moving on to Viren, now let's talk about strategy. There would be occasions when you have encountered scenarios where the counsel for a party weaponize the due process concern purely to create grounds for challenge. Now, what is your advice for tribunal to deal with such gamemanship without compromising fairness?
Sure. I will play the role of the naughty lawyer who's going to try to undermine the process, and I'm sitting next to what was described as a force of nature arbitrator.
We want you to talk about the dirty tricks.
The dirty tricks, okay. This is not me always, but sometimes perhaps. The reality is, cases should be decided on their merits, obviously. But sometimes a party, more often than not the respondent, but doesn't want to be in this forum and wants to make the life of the tribunal hard, and in a way create a record, right, relating to due process, therefore like shown through procedural tactics, to tee up a potential annulment ground, right? And the reason is because annulment grounds typically are very limited under the national laws of most jurisdiction, and the non-enforcement grounds in the New York Convention go towards key issues regarding notice, constitution of the tribunal, and then perhaps in the extreme international due process requirements of equal treatment of the parties and the right to be heard not having been met. So here are the kinds of things you can do if you want. But bear in mind, you bear the wrath. You incur the wrath of the tribunal, and you're likely not to be successful. One is challenges to arbitrators. I think we're seeing more and more challenges to arbitrators now to unsteady the process, perhaps gain a short-run victory if someone is replaced and sort of perhaps instill some caution in them regarding procedural decisions that are being rendered with a view to getting something more favorable because the specter of another challenge is on the horizon. So that's something we're seeing more, especially in investor state cases, but also in commercial arbitrations. The second is seeking extensions of things that have been set out in the procedural timetable, right? And it might not just be another day or two, but a week or 2 weeks or a month. And what knock-on impact does that have on what is to come next in the arbitration? And if you are to grant those extensions, must you do it equally to the other side? And if you do so, do you blow up the rest of the calendar? The third is, especially in international arbitrations, unevenness in the document production phase. When you have two domestic parties from the same jurisdiction who are represented by counsel from the same jurisdiction, who are before a tribunal of lawyers or judges who come from that same jurisdiction, there's an understanding typically of how things are going to go. But when you have civil law and common law and parties from different places, counsel from different places, and tribunal members from different places, there can be that unevenness where you can exploit, and I say this as, I'm a US trained lawyer, and US discovery is a big deal. And so there are questions then about how you can use that process to talk about fairness. Did I get access to the documents? What you tribunal granted or should have granted in response to my requests that the other side was not producing can be used appropriately, but can also be weaponized in certain instances. Another example of tactics, good and bad, are late introduction of evidence. Usually there is something set out in the procedural calendar for when documentary evidence should be submitted, witness statements and expert reports, and when any rebuttal evidence should be permitted. But you will see late introduction of evidence, oftentimes on the eve of the hearing. This is material, dispositive stuff. Without it, you can't actually decide this case. You must let it in. If you let it in, do you let the other side let their material, dispositive stuff that they didn't submit early in the matter in or not? That's another sort of thing that we see. Sometimes there are requests to postpone the hearing, which with busy arbitrators can result in a lengthy postponement. So what are the grounds for requesting that postponement? And then, there's a lot of requests for reconsideration. You decided this procedurally, or you decided this decision that isn't final in the sense of a final award. So can you reconsider it? Maybe we have new evidence, perhaps new evidence that you let in because I filed in something late. What do you do with sort of principles of res judicata? Was that a final decision? Something new that was not known to the party and could not have been known or should not have reasonably been known to the party, change your mind? So we see a lot of requests for reconsideration. And sometimes alteration in the requested relief. The ICC has the terms of reference that are meant to sort of capture at an early stage what the parties are seeking in the forms of claims and counterclaims. Not all rules have that provision. And you normally will see, and I will include myself too, in the request for relief, and any other such relief that the tribunal deems just and proper, and I'll reserve my rights. And some of this is completely appropriate, right? Especially, for example, with calculation of damages, the number may be evolving, you have to see what the expert reports come in, you're updating your interest, depending on the passage of time. But sometimes you have to really track that requested relief because what is being pled throughout and what's being asked of the tribunal ultimately doesn't always line up. So I know there were two parts in the question of, what can you do, the dirty tricks, and what can a robust arbitrator do? I'll defer to the arbitrators and judges here on how to respond to these kinds of things.
Thank you, Viren. I think this discovery and some of the tricks that are played are important. But I saw a very enigmatic smile playing on the lips of Michian while Viren was responding. So can you just put a little bit of your own input on this question, on some of the tricks that, share?
Thank you very much. I was listening to Veer and I was like, he must have written the textbook on this because this is in every
tricks too.
Certainly a lot of these tricks have featured in a number of my cases, and I thought, my goodness, he's just doing this checklist for many of my cases. And so what can we do as tribunal members to be wary and be mindful of these tactics that will invariably play a role in some of our arbitrations? I think the flag that Viren mentioned on reservation of rights, there are certain code words I think you see in correspondence that starts to allow you to be alive to the fact that there could be a paper trail being formed by one of the parties who might seek down the line a challenge or to create some mischief later on in the proceedings. And in general, I think one of the ways in which to preempt that is to create your own record as to what the applications are looking like and the tone of the arbitration. And certainly if you have a living procedural history, whether in a form of a list or a chart, you can start to see and ensure that you are also being mindful of the number of applications that are being brought to you as a tribunal, and the exchange, ensuring that you give both parties the opportunity to be heard on each of those proceedings, but also to stay firm as to how you deal with those procedures. Obviously, the substance will be dealt with on the application itself, but you also have to be mindful as to what that potentially mischievous party may be doing and how the tone of which they might be creating or for that trail that they're creating. And so you might want to make sure that you can generally sense that when you are engaged with a particularly contentious arbitration. I would also say that it's important to also be able to have tools in your own toolbox as to how to deal with regular requests for extensions. So for example, in certain arbitrations, it may be, you have a firm date for the hearing, and you start to see the slippage of time. Obviously, you want to make sure that any requests for extensions do consider that potential slippage of time, but as well, you may want to create some precedents for the parties and inform them that they might not be able to, they might have 5 days here, but if they have 5 days here, they might not have 5 days later on. And so they have a finite number of extensions or days that they can use for those requests. And so there are certain ways in which you can kind of ensure that you preserve the sanctity of the proceedings, being quite mindful that there is much mischief at play.
Thank you, Chan. Before we proceed to the next part, and we'll discuss here on enforcement of emergency orders, let me first compliment Shaneen on bringing a bit of a color amongst the panelists, gray all around. Shaneen, so therefore you are the target of my question. My question is, when urgent relief is needed, how do you choose whether to pursue emergency arbitration or go to court? This is the first part. And what are the enforcement trade-offs and jurisdictional risks that you factor in choosing the remedy for urgent relief? And I think Viren might also chip in on this. First, Shaneen.
Thank you, Justice Roy. Also for what I will take as a compliment on my jacket. So I think Viren's going to touch upon a very important point, and that is the difference between emergency awards and emergency orders, because I think, that really depends on whether the decision that you're talking about is enforceable. But I'm going to touch upon emergency arbitration generally. Nowadays, most global institutional rules provide for emergency arbitration. What is emergency arbitration? It's the ability to seek urgent interim relief prior to constitution of the tribunal. Now, our Act currently, as it stands, does not provide for emergency arbitration. It's a relatively new concept. Our Act is of '96. I think this came up in the last 10 years, maybe? Less, 5 years. Anyway, our Act doesn't provide for it. And because an emergency arbitrator is appointed, it is uncertain whether such an arbitrator, who is not ultimately deciding finally on the arbitration through a final award, could a decision from such emergency arbitrator really be, one, treated as an award or enforced? Justice Nariman, who is absolutely brilliant in one of his seminal judgments, cured part of that lacuna in the Act for us insofar as domestic arbitration is concerned, to say that if you are arbitrating under institutional rules like the ICC, which provide for emergency arbitration, in an Indian seated arbitration, an order received by such emergency arbitrator will be treated like to like as an order under Section 17 by a domestic tribunal, and therefore enforceable. So no problems if you've got institutional arbitration. Of course, if you've got ad hoc arbitration, there's no question of appointment of an emergency arbitrator. Who agreed to that? Who's going to appoint that arbitrator? The problem arises if you have a foreign-seated arbitration, which is not governed by Part 1 of the Act, Section 17 being in Part 1, enforceability of interim orders of domestic tribunals being in Part 1. Part 2 deals only with referring parties to arbitration and enforcement of foreign awards under the New York Convention. And therefore, I slightly overlap with what Viren will deal with, is therefore an order that comes from an emergency arbitrator seated outside India. There's no scope for that kind of enforcement directly in India. And therefore, the route that is often taken, if you go for emergency arbitration outside India, and I will tell you that I generally don't unless confidentiality is required, is to then file a Section 9 in an Indian court for interim relief, the same relief. So to answer the first question, if it were an Indian-seated arbitration, if confidentiality were an issue for me, if there was something technical that needed to be decided and I wanted an arbitrator who would likely have subject matter expertise, because of course Tejas will consider who to appoint as emergency arbitrator, I might then opt for emergency arbitration. If, however, confidentiality was not a concern, or in fact I wanted it out in the public domain, I may go to an Indian court. If I wanted ex parte relief, whether against my direct counterparty or a third party, I may go to an Indian court. Now, while our Indian courts are notorious for the length of time in coming up with final decisions, they act overnight insofar as interim relief is concerned. So I might actually find that an Indian court is more efficient if I want urgent interim reliefs. So in terms of speed, I might choose an Indian court. If it's a foreign-seated arbitration, I would probably choose an Indian court. And of course.
We'll have some time for response also.
Viren, maybe you can
Viren.
pick up.
I'm happy to pick up. It really depends on the institutional rules. Tejas, you'll correct me. I think the ICC, their emergency orders, and I think it's to avoid the scrutiny process of an award. In the ICDR, for example, in the US, the AAA ICDR, the rules say it can be an order or an award, and so you see there what the parties are seeking and why. I will say that being an emergency arbitrator is difficult because oftentimes these rules put very strict limits on when you have to render that order or award, but it matters. I sat as an emergency arbitrator under the ICDR rules in September of last year. It was a dispute between an Israeli party and a US party over the licensing rights in the United States of a documentary about Hamas. And it was very important to the parties to figure out whether the US party could distribute that documentary because they wanted to do so in advance of the upcoming then November elections between candidates Trump and Harris. And so I had to figure out very quickly then what relief to be granted. And it was made clear to me in the briefing that if the order was to direct that the US party could distribute this documentary, that they would seek enforcement of that in the Israeli courts. And then it would have to be treated under the laws, Israel's treatment of a foreign emergency award or not. And so these questions, really are, what does the institutional rule say? What do the rules of the seat of arbitration say? And what may the foreign rules, and this is Shanine's example, in this case the Indian rules say, in my case the Israeli rules say about whether you have to enforce a foreign emergency arbitrator order or award. So just a bunch of things to take into account.
Now, my next question is for Ms. Chian. if we move towards the practicalities of finalizing an award, now you are a very experienced arbitrator. Can you tell us how often the available article for corrections are misused for post-award clarifications? Also, do you notice any strategic misuse of correction requests? Also, please tell us the requirement for wet ink signature versus electronic signature on arbitral awards and how either choice play out during the process of enforcement.
Great, thank you very much. I appreciate that we are running out of time, but I do want to address these 2 points, which I think are useful and I think commonly seen, or at least for the first question, more commonly seen than in the past. And I would add this point about, I think it's Article 36 on corrections as part of the many tactics that may be played, more often tactics than true correction requests, as part and parcel of what Viren might use as counsel in creating some mischief. And so what I would say from a tribunal's perspective is to be firm and to be very clear in dealing with these requests. Obviously, the institution has to process these requests, and obviously the tribunal has to take them seriously, but oftentimes you will see very quickly what the nature and the tenor of the requests, and to deal with them firmly and succinctly, I think, is probably the best course. Sometimes it will also be in a sense of paper trail again, but also in the sense of creating some opportunity for an opening of interpretation. And again, you have to be very careful as to what how you respond to those. So I just wanted to flag that as part of this overarching dialogue that we're having. With regard to wet ink, I think that topic was thrown in mostly because it still remains quite a clunky system that we live in, where the lack of wet ink signatures could create the question as to the enforceability of the award in certain jurisdictions. I would love a system where we could harmonize and just allow for all jurisdictions to create an understanding that wet ink or electronic signatures were equally valid. And I encouraged the ICC, and I wanted to kind of raise it in this context to further investigate that particular issue, because I think it is something that we as arbitrators and parties probably find to be increasingly an antiquated exercise.
My next question is to Tejas. Now, when ICC panel scrutinized draft awards, can you please tell us how it works in practice and how the institutional scrutiny can make the award enforceable? And more particularly, you will please enlighten us whether the ICC follows a light touch approach or a hands-on approach in making the scrutiny.
The ICC approach is certainly not light touch. I think one of the true value propositions of the ICC is that the ICC scrutiny truly stands out compared to any other arbitral institution. And the reason I say that is that the ICC has a 3-level scrutiny process. So no award can be notified to the parties until and unless it has been approved by the ICC court. When we use the word ICC court, it is not just a body of 10, 15 people. It's a court which comprises of 1 president and 190 court members and vice presidents. Chian was, of course, one of the vice presidents of the ICC until last year. So the first level review is done by the case management team. So for Indian parties, probably goes to Singapore. The second level review is done by the management of the ICC Secretariat, which is the managing counsels, the Deputy Secretary General and the Secretary General. They will then prepare a document and release it to the court, the ICC court, which has court members from different jurisdictions, including India, from where we have a vice president and 2 court members. Now the rules provide that the court will make changes as to form and draw the attention of the tribunal as to matters of substance. Are we telling the tribunal that you got it wrong and you must change your decision to hold company A liable against company B instead of company B? No, we are not doing that. What we are telling the tribunal is that, of course, there are issues which are editorial, for example, commas, spellings, so on and so forth. There are issues with respect to calculations, so many a times the tribunal may award interest. How is the interest calculated? Is it simple interest? Is it compounded interest? How did you reach the magical figure of 12%? Is interest permissible? Certain jurisdictions you cannot award interest. certain seats of arbitration you cannot award legal costs. And then we draw the attention to matters of substance. For example, have you taken into consideration the relief sought by all the parties? Is the dispositive very clear? Because one of the grounds for setting aside an award under the New York Convention is also the lack of reasoning. And all of this to say that this is, of course, a process that takes about 3 to 4 weeks maximum. But we see this work in practice. And to give you some stats, last year, the ICC notified about 577 awards. Out of those, 564 awards had comments from the ICC. So they were approved in principle, but they had comments from the ICC. And 10% of the awards outside of this, or almost every year, are not approved at all. So they're sent back to the tribunal to redraft. Now, if there was no ICC in one of these cases, then you would have an award that you would be making an application to set aside. And I say this with absolute humility that I don't think any institution can guarantee enforcement. Because enforcement, the courts in their wisdom might think something else, or the institution might miss out on some issue, because in the end, this is a human process. But all in all, I think we certainly see this to work.
Thank you, Teja. I think that was very important. But in a panel discussion, although Shaneen had touched on, artificial intelligence being used, deployed by, party appearing in person, can we just have a little bit of technology input on AI-assisted awards drafting, for instance, or arguments before the tribunal within?
Sure, and I'll keep it short because I know we're running out of time, and it's a big topic, right, on the use of AI by parties in an arbitration, and also the use of AI by arbitrators. So I'll shortcut it by saying that the Chartered Institute of Arbitrators issued guidelines earlier this year, sort of guiding parties and arbitrators on the treatment of AI. The Silicon Valley Institution in California has also promulgated its set, and other institutions are working on various guidelines. So I guess I would say to you, read the space as stuff comes out, because I think it is useful. My main takeaways from these guidelines that are coming out are, ultimately one of the important issues for enforceability is that the tribunal and the arbitrators are neutral, are independent and impartial, right? And so the question is, if you are using AI, there are questions then of AI bias regarding the data set and the questions that are being posed of it, et cetera. So that is one area that arbitrators have to be conscious of. The other is a strong recognition in across the board that the use of AI does not diminish your accountability and responsibility, both as counsel and as the arbitrator. So you can't, in a get out of jail card, say ultimately, oh, but it was the use of AI that I tried to use responsibly that resulted in this outcome. It's also very clear that you can't relinquish important decision-making to AI. It can facilitate your reasoning and thinking, but ultimately you have to independently verify your legal reasoning conclusions and the outcomes that you are generating. And you have to be conscious of the rules of the seat of arbitration, but also the enforcement potentially as to whether they have said anything on the use of AI in coming to reasoned awards or not. So you've got to telegraph that in advance and deal accordingly. Most parties don't want to disclose whether they are using AI. They sort of view that as that's how the sausage is being made, and that's not the role of the arbitrator to know. Shaneen mentioned that in her case, the pro se plaintiffs parties may be using AI. I just received a submission from one of my parties that I suspect is using AI, which is putting me on notice to double check the hallucinations that might exist, and that burden has been transferred to me, but it is my responsibility as the arbitrator to make sure that what I think is the law that's being pled by the parties is accurate. I'll give one cautionary note. Jian had a very good discussion with Justice Roy in which she talked about being a marathoner. That's okay. But in another conversation, there's a vacator application that's happening in California right now, where during one of the breaks, the arbitrator said to one of the parties, I use ChatGPT quite a lot, both to plan vacations, but also to draft articles sometimes for me. And so the award was rendered. It went against, obviously, one party. That party asked ChatGPT, could you look at this award and tell me whether you think it used AI in the reasoning and drafting? And ChatGPT apparently spat out the answer, yes. It seems likely. And so that vacator application is now pending before the court regarding the use of AI and whether, I don't know, we don't know the outcome yet, but the applicant points to certain facts in the arbitrator's award that is not found in the record. They also point out to law that is not found in the record, but that may be, the arbitrator went outside the written submissions, but it might still be good law and cases that are being cited. But on the factual question, certain things that didn't seem to exist were in the ultimate award. And so I guess it's a cautionary note, but it's also the case that as we're seeing parties use it more, I think you have to think about using procedural orders regarding the use of AI. There are draft procedural orders that the Chartered Institute attaches. They are pretty basic, partly because this is such an evolving area, but I guess it is just keep it in mind that you have to think about ultimate enforcement, and you can't use a caveat of, it was AI's fault ultimately.
Thank you, co-panelists, everybody. Those in the audience, the clock that is going backward may not be very visible. But Justice Subramanian Prasad has just stepped in, and he's the timing umpire. And if we are able to finish before the clock goes to 0, we have an incentive. We are not going to tell you what the incentive is, but all the panelist members have an incentive that is being promised by the DAW organizers. But thanking the organizers, the team, Mr. Subramanian Prasad and everybody in the Delhi High Court, and such a wonderful participating audience, and the co-panelists, including Shaneen with her bright jacket, we would like to conclude this session. Thank you. Thank you, everybody. Thank you. Thank you.
May I please request Honorable Mr. Justice Prasad to felicitate the Honorable Chair and the esteemed speakers of the session by presenting them with a Prabhavali. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring traditions of artistry and design. We hope it serves as a meaningful reminder for your time at the Delhi Arbitration Weekend 2025 and of the timeless elegance of Indian craftsmanship. Thank you.
We go down for our incentives now.
Yes.
Yeah, absolutely. Yeah, it just went to 0 actually. Come. Yeah. Come, Viren. Shaneen, you must come in.
Thank you.
Thank you very much.
Lovely. Chian, very nice. Very nice. Yeah, Tejas, thank you very much.
Thank you, everyone. The next session will be beginning here at 12:10 noon. Thank you.